All right, welcome everybody to From the Beach to the Bar, speaking about growing up near the beach and then coming to become a lawyer. Today we're going to be talking about the idea of fault and how fault plays in both the criminal perspective and in the personal injury perspective. Obviously, fault is very important in criminal cases because that determines whether you go to jail or not. And in personal injury, fault is very important because that determines if you get paid or not. So it's an incredibly important concept in both areas of law, just kind of different. Sage here, we're going to bring up any time. And by the way, this is Sage.
Hi.
And Sage will be bringing up some topics, I think.
Yes.
And what are you bringing up?
So there's a few big celebrity cases that there's a little touchy difference on being at fault. There's the Tory Lanez, Tyreek Hill, Lil Baby. So they all have different types of cases that we can talk about. Go ahead.
Perfect. So let's talk about what does fault mean. And so fault essentially means in a personal injury case, who is the person that caused the accident? Who is the person that created the situation that led to an injury? Who is the person who's going to pay? That's the way to break down what fault means in a personal injury case. In a criminal case, fault determines who is the one who potentially committed a crime, or, to be fair, who's the one looking at paying some money or going to jail. And so fault is held at a much higher standard in a criminal case than it is in a personal injury case, but both are standards that can be met and have been met throughout my 20 odd years of doing this job. Now, common misconceptions about fault. My favorite one, and I just had a conversation with a guy yesterday, it's actually a crossover. I had a gentleman yesterday who called me and he had just been released from jail. And what it was he was in an accident where he was T-boned. So that would suggest that the other person was at fault. But when the officers arrived, they came and he appeared to be under the influence. So the officers ran him through the field sobriety test, and based on his performance there, he was arrested. So while he wasn't at fault for the accident, it appears he may have committed the crime of drinking and driving while under the influence. So we're going to have to determine if he truly was at fault in the criminal perspective while not being at fault in the civil perspective.
Okay, Ben, so can someone be less at fault but still liable?
Yes, most definitely. In situations where there are 3 car accidents, for instance, say 2 people are stopped at the light and all of a sudden a third person comes up and hits the middle person or the second car, obviously that third person is at fault, but the second car can be at fault. Say they were too close to the car in front of them, say they didn't have their brakes on, say they actually hit their gas instead of the brake when the gentleman behind them hit them. In that situation, while the second car really didn't do a lot wrong, they still caused injury to the third car. And so in a situation like that, it's kind of on the guy behind you, but at the same time, you committed the act as well, so you can be found liable in that situation.
And how do you approach determining fault in complicated cases?
Well, I guess the best way to put that is if fault is clear, it's never going to go to trial. We're going to resolve that case fairly quickly. And you'll find that about 96%, a pretty high number of cases, it's pretty straightforward in the personal injury category to determine fault. But in situations like criminal, a lot of it, hold on. Let me think about how to answer that one, right? How do you approach determining fault in complicated cases? From a criminal perspective, fault can be pretty clear. You either did it or you didn't do it. And then in certain situations, there's something called conspiracy. Say that 3 guys go to rob a bank and one guy's the getaway driver and the other 2 guys go in and they shoot and kill somebody. Now, the driver didn't necessarily want somebody to be shot and killed. However, because they were in a conspiracy with the other 2 individuals, they can be held just as liable in a situation like that for murder. And so in a situation like that, you definitely need to negotiate very hard before you decide to go to trial, because in a situation like that, with the conspiracy law as it is in this state and in the state of California and in the federal system, something like that is going to mean you are liable for the murder as well.
Going into what you just said, there was a NHL player who just unfortunately passed away from being hit from a DUI or a drunk driver. So
here's the situation. You're talking about the Johnny Gaudreau situation. It was incredibly sad. Johnny Gaudreau and his brother were on a bike ride getting in condition for the season, and a gentleman came up, hit them, and killed them both. What you didn't know is that happened on a Friday, and his sister was getting married on Saturday, and both brothers were actually in the wedding, so it was heartbreaking. They just got the gentleman's blood results back who hit the Gaudreau brothers. He came back at a .087. Now, there's something called the margin of error, and what the margin of error is that saying, like, a breathalyzer isn't perfect, or a blood analysis isn't perfect. And the margin of error says, for instance, for a breath result, it's usually about, I'd say 10%, 0.08, 0.008 in the margin of error. So theoretically, that guy could have been at a .079, which is 0.001 under the legal limit. However, he would still be prosecuted because even if he is just under the legal limit, he still had alcohol in his system to a degree that it affected his driving. And as a criminal defense attorney, it's hard to argue that alcohol didn't affect your driving when you killed two people. So it's problematic for that gentleman where he might have an out in terms of his blood alcohol level. Two people are dead. So in a situation like that, he's going to still have issues.
Okay, Ben, what's the craziest situation where you had to prove fault?
Well, like I talked about before, usually in both situations, criminal and personal injury, fault is usually easily determined. There are situations where fault can be in question, and it's mostly in the personal injury situation where you don't have all the evidence. And I had one case where, let's just say it is somebody who had addiction to meth.
Okay.
She might have been at a store. She might have just slipped, flown way up in the air and landed and tore her knee. Now, here's the situation. This is what I tell people all the time. And that's like the 15th time I've said, here's the situation. But I take my clients and I represent my clients no matter what. In a situation like this, the woman was injured through no fault of her own. She just happened to really, really like meth. I don't mind. You do your thing. As long as you're staying out of trouble, we're all good. But we did come into a lot of, what's the word I'm looking for? We had an issue determining liability or determining fault because the store said, no, we're not going to pay. And I said, she slipped on your floor, on a wet floor, and tore her ACL. And they're like, no. So we eventually had to sue them. We eventually got a copy of the store's camera. And lo and behold, it was the funniest thing because you see them pick up a wet sign, mop the floor, don't put the sign down, and as they're mopping the floor, they put it in, they put the mop back in the bucket, water splashes. Literally not 10 seconds later, she walks by and falls flat on her ass. It was kind of funny, I'm not gonna lie. But at the same time, it took an extra step in that situation to prove fault, but once we had the video, once we had the additional evidence, in spite of her love of delicious meth, we recovered on her behalf.
That is definitely crazy. As a lawyer, is fault one of the main things you argue or fight for in a case, or do you take another approach when representing your client? Explain your approach.
Here's the situation. Fault or in a personal injury context, liability. Though that's kind of the step one, and it's a big step one. When you're talking to a client, be it criminal, be it personal injury, you need to know, did you do it? And for the record, in criminal, you never ask that question. But for personal injury purposes, when I'm talking to you, I'm finding out if you potentially can be at fault. In a lot of personal injury cases, say the accident happens in a parking lot. Typically, officers aren't going to come. And it's going to be, for lack of a better term, a he said, she said, or a he said, or a she said, she said. But the whole point is it's word versus word. So one of the first things you do in a personal injury case is you have to assess the credibility of your client. You're talking to them, you're seeing if they would answer your questions correctly. You're also looking at the evidence you do have in front of you, be it photos of both cars to see how the accident potentially happened. But in a personal injury context, the most important thing to do is determine who's at fault. And sometimes you can't, and you have to figure it out. But sometimes it's clear either way. And in a situation where it's clear in favor of your client, you take the case. In a situation where it's not clear, or you just don't think things are right, in that situation, you decline.
Okay, so how often would you say you decline cases in personal injury or criminal? And if so, why?
In criminal, it's very rare. If you're going to pay me money, I'm going to figure it out. Even if you're dead at fault, we'll figure something out. What I always say in a criminal case is just because you did it doesn't mean you're guilty of it. But in a personal injury case, it's really going to come down to two things, like I talked about. The initial evidence you provide me and the credibility you give me as a human being. If I have a situation where what you're saying doesn't make sense, or I feel like you're holding something back, the odds are pretty good that we're going to decline your case. And the reason being is, if you're not convincing your attorney, how are you going to convince a jury that you're telling the truth? And it's, like I said, having done more jury trials than 99% of attorneys in the nation, I can tell you for a fact, I have a good idea of what a jury's going to think.
Yes. I do think I find it I feel like working with you, I do find it amazing that people are not very honest with you, and I think that you always are trying to have the best interest in their clients, and something that I feel like them being honest is something that they should say, because at the end of the day, you are helping them. So I
always tell them I'm your lawyer, not your priest.
Yes.
Right? And do with it what you will.
Okay, so if you could have a dream scenario for a case you could take, what would it be?
Well, I mean, the problem you ask a person a question like this, you really find out how their mind is, and sometimes the things we think are fucked up. So, I mean, to be fair, we'd have a situation with somebody who's in an Ivy League law school who is driving his grandmother to the hospital so she can get some life-saving medication, and a Walmart truck decides to run them over with a gentleman in it who's had 2 prior DUIs and is probably under the influence. All the while, an officer is sitting at the intersection watching this all go down, and said law student, Ivy League person with sweet, sweet grandma dies. That's a dream scenario. It's a fucked up set of facts, I'm not gonna lie, but at the same time, that's kind of perfect. You're going to get a check written very quickly in that situation.
Are there things that you prepare your client to be more likable to the jury, or appealing wise, like appearance or BBLs, makeovers?
What the fuck's a BBL, Sage?
It's a Brazilian butt lift.
Well, here's the situation. They're sitting down the whole time, so the Brazilian butt lift isn't necessarily going to work. But what do you do to prepare your client to be more likable? The first thing you do is you try to find likable clients. There are times where your client just isn't likable, and in a situation like that, you'll probably try to settle a case. But if your client is a likable person, they listen, and they can follow your directions, then you're going to be good. Now, how do I prepare them? Haircut? It depends. If you got your little man bun and it's tucked back and it looks good, you're fine. If your hair's all over the place, probably going to have you rein it in a little bit. Obviously, you're going to court, you're not going to the club, so dress accordingly. And sometimes people just don't get it, and so you have to have them out a little bit and say, maybe we just tone this down a little bit. But you also limit your client's time with the jury. In a situation where you're in trial, your client doesn't necessarily have to be there for the entirety of the trial. Some people want to be there, but in certain situations, it's probably better if you just have them in there for the first day so they meet them, they get their testimony in, and then they're out. Because you don't want a jury looking at your client the whole time. What if your client picks their nose without even thinking about it? Does something that the jury finds, offensive in some way, shape, or form. The less contact your client has with the jury, the better for your client.
So for celebrity cases, are there biases they have to deal with when dealing with a jury based on their appeal to the general audience that could affect their case?
OJ is the perfect example of this. OJ, when he was tried, and realize I'm older than all y'all, when he was tried, he was Nordberg from the Naked Gun series. So everybody liked him. He was selling isotoner gloves, ironically enough, and things like that. People liked OJ as a person. And then you have a situation where OJ killed, or might have killed, his ex-wife and a waiter at a restaurant she goes to. He had credibility with that jury before he even walked in the room. They didn't see OJ the person, they saw OJ the celebrity. And so in that situation, they had somebody who they had been in their living room for a large part of their life, so they trusted him. Now, in a situation, I represent or have represented quite a few fighters in the past. Fighters always have that prejudice when you walk into court. People are thinking this is a violent person. What people don't realize is most of those fighters, college educated, they've been around for a while. By and large, they stay out of trouble. There's knuckleheads and things like that. But there is a bias in a situation like that. Now, you have situations that we're dealing with, and we talked about earlier. We have Tory Lanez, okay? Tory Lanez just ran into some trouble with the prison guards, right?
Yes.
And I'm relying on a little bit of research I did before because I have no clue who this dude is, except I do know he whooped Megan Thee Stallion's ass and shot her in the foot. And so I instantly don't like that guy because Megan Thee Stallion is a national treasure, people. And so in this situation, is he doing good, or in this situation, am I going to hate him? So that can play a role. Your prior crimes, your prior actions can play a role. OJ, once again, is a perfect example. We liked Nordberg when he was in for the murder trial, so we believed him and he found not guilty. When he came to Vegas and decided to try and get some of his shit back, people wanted to convict him not of trying to get his shit back in the robbery, they were convicting him of the murder. And so OJ got punished in that second trial because what he did prior to. So that definitely carried into the trial with him.
Okay, so going off the top of what you just said, I'm not OJ type. I'm youngin, so I have the little
like me.
I have the little rappers. Lil Baby was just arrested here in Las Vegas for gun charges. So is that because he can appear just like the fighters would, a little dangerous, or I guess profiled, I guess you could say.
Well, yeah, in a sense. I mean, look, here's the situation with Lil Baby's case. Is he was in a club, there was a gun, he could legally have a gun in Georgia, but he's here in Vegas, and you can't have your Georgia license here in Vegas. But the long and short of it is this. Rappers are always going to be associated with two things. Carrying guns and hitting bitches. Pardon my language. So, it's going to be hard for him to say I had a legitimate purpose for having my gun, especially because ever since Pac got killed in Vegas, we're a little bit touchy about rappers and guns. And so, in a situation like that, the fault before he even walks in court is going to be, dude, you had a gun. It's that simple. And so one of the beauties of the attorney he has is that he's very connected, and I have a feeling that that case will be negotiated prior to.
Okay, Ben, so there's another event that also just occurred with Tyreek Hill, the football player. There was body cam footage. I don't know if you got a chance to see it. What are your thoughts on that? Did you see that?
Well, that's great for two purposes. One for the criminal part and two for the personal injury part, because most people don't think about it. But what you have is you have a black man in Miami in a McLaren, which is a $350,000 vehicle at the bottom end, driving, and you have some traffic cops who aren't necessarily happy with Tyreek. Now, I don't know if Tyreek did anything truly wrong. This is a minor traffic matter. But if you notice, most of the African Americans who get killed in these matters, it's not like cops are executing a search warrant usually. It's a situation where it's a traffic stop. And what we have is we have a traffic stop of a black man in a $350,000 vehicle And the officers, I guarantee you, knew how much that vehicle cost. And so they were a little bit aggressive in the way they dealt with Tyreek. Now, Tyreek's a pretty funny dude, and he's a bit of a smartass, and you could see that in the way he responded to the officers. But the officers were definitely aggressive and hostile in the way that they addressed the issue. I find it telling that with the introduction of body cam, we now have an officer who's being investigated by internal affairs, and we have a situation where Tyreek does not appear to be charged with a crime. Like he could have been speeding, you're talking about a car, I don't know what the horsepower is in that thing, but it's ridiculous. He could have been speeding, he could have been driving like a jackass, but at no point during his interaction with the police did he need to be in custody. Additionally, he had teammates pull up because they were going to the game. Miami had a game that day at the stadium. So he had teammates pull up, and Calais Campbell, who's a huge dude, he's like 6'6", 300 pounds, he gets out of the car and the officers immediately cuff him. If you get in trouble or you see a friend get in trouble, it's probably not a good idea to stop. The reason, especially if you're a 6'6", 300 pound black man, the officers are going to consider you a threat. You're not a threat, but you look like one, and so that's what they did, So in that situation, Tyreek may have been in fault of a minor traffic offense, but nothing rising to the level of being placed in custody, thrown on the ground, and treated like an animal. One of the things that's important too is in that situation, because he's a personality, because he has been treated wrongly, like in a lot of ways, that's an excellent personal injury case as well. He's been falsely detained for, at best, a minor traffic ticket. You have officers that are acting outside the color of their authority, and potentially it not only affects his reputation, but it affects his ability to make money. And in both situations, I feel that Tyreek has an excellent case for suing Miami PD.
And Tyreek, he rolled up his window after talking to the cop. Do you have to keep your windows rolled down, or can you roll them up after, or do you comply with what they say, what the officer says?
This is what I will tell you. While Tyreek was a smartass, by and large, he was complying with the officers. I always tell people to kill officers with kindness, meaning be overly nice with them. Follow their directions. The only time I would ever keep my window up is if I was drunk. And so you don't want them to smell the odor of alcohol on your breath. So in that situation, I'd be like, I'm not going to roll my window down. But in his situation, he has murder tint on those cars. I mean, they're dark. He probably should have rolled his window down. And, did he do it quick enough? I don't know. But did they have to get out of control? No.
All right, Ben, so we talked a lot about at fault or not at faults. Any final thoughts? Any final thoughts?
Like I said, fault is incredibly important in both. Fault is important in criminal because if you are at fault, you're going to be charged with a crime. And fault is incredibly important in personal injury because if you're not at fault, in all likelihood, you're going to get paid. And so fault is one of the first things a good attorney is going to assess, and one of the first things an attorney is going to talk to you about. And the more you try to convince somebody, the less likely you are going to appeal to that person. Fault is easily determined. It's just a matter of listening and going from there. Remember, in personal injury cases, this is about likability. This is about credibility. So all you have to do is tell me your story. Don't sell me your story. Tell me your story, and we can take care of it. On the next episode, we're going to talk about social media and how social media can affect your cases, both for the positive and negative. And trust me, I know of at least one case that it cost a girl $1 million because of social media.
All right, thank you guys for listening. If you have any questions or concerns or a case, you guys can give us a call at 702-545-7592.